What happens when the government bans the single most popular rifle in America, the AR-15, and the courts let it stand? Well, that's exactly where we are today, but the Second Amendment Foundation and Firearms Policy Coalition are taking that fight to the Supreme Court. This could be the defining case on so-called assault weapon bans in America, and it's one that you need to hear about. The Second Amendment Foundation, along with FPC, Firearms Policy Coalition, has officially filed a petition, a writ of certiorari, asking the United States Supreme Court to review the Viramontes v. Cook County case. The case challenges Cook County, Illinois' ban on so-called assault weapons, a law that specifically prohibits AR-15s, AK-style rifles, and dozens of other semi-automatic firearms by name and by features. Cook County's ordinance makes it a criminal offense for a peaceable citizen to simply own one of these rifles. Violators face seizure of the firearm, up to 6 months in jail, and a minimum of fine of $5,000. Now, the petition asks a simple but profound question. Do the Second and 14th Amendments guarantee the right to possess AR-15s and similar semi-automatic rifles? What say you? What's up, everybody? Jared here with Guns and Gadgets, your premier source for Second Amendment news that you won't hear anywhere else. If you care about your rights and want to stay ahead of the fight for the Second Amendment, hit the subscribe button today. Join this movement. It doesn't cost you anything. It's free. And Patriots, if you love America and you love your coffee strong, you got to check out Blackout Coffee. This isn't your average store-bought brew. It's premium, small-batch roasted coffee made right here in the United States of America by people who love freedom as much as you do. Every single bag of our coffee is roasted fresh, so that you're not getting coffee that's sat on a shelf for months. You're getting rich, bold flavors delivered straight to your door. And when you support Blackout Coffee, you're supporting a company that proudly backs the Constitution, our Second Amendment, and hardworking Americans. Start your mornings the right way, with coffee that tastes as good as freedom feels. Head over to blackoutcoffee.com/GNG, and for a very limited time only, you use Labor Day 25, save 25% site-wide. Got to do it now, though. blackoutcoffee.com/GNG. Link is down below. Wake up like a patriot. All right, this isn't just about Cook County, Illinois, guys and gals. The AR-15 is the most popular rifle in the United States. The Supreme Court itself has already acknowledged that fact in Smith & Wesson Brands versus Mexico early this year. Now, some key stats presented in the petition. Our surveys show that 16 to 24 million Americans own AR-15 or similar style rifles. Now, they account for around 20% of all firearm sales over the past decade. They are widely used for home defense, target shooting, hunting, and competitions. And despite their popularity, rifles of any kind are used in only about 380 homicides per year nationwide, meaning over 99.999% of these rifles are never used in crime. So if the Second Amendment doesn't protect the most commonly owned rifle in America, then what does it protect? That's the crux of the issue here. And here's how we got here. In 2021, SAF, FPC, and individual gun owners filed suit against Cook County, this very case. And by the time this case reached summary judgment, the Supreme Court had just decided the Bruen case, which clarified that gun laws must be justified by the text of the Second Amendment and consistent with this nation's historical tradition of firearm regulation. But the Seventh Circuit Court of Appeals upheld the ban anyway, in violation of Bruen. And they leaned on the earlier decision in Beavis versus Naperville, a case where they said AR-15s aren't even arms under the Second Amendment because they're supposedly too military-like. Now, according to the Seventh Circuit, the AR-15 is almost the same as the M16, that's a quote from the case, and can therefore be excluded from constitutional protection. That reasoning is a complete distortion of Heller and Bruen, and the Supreme Court already said in Heller that arms covers all bearable weapons, even those not in existence at the founding. And the only arms that could historically be banned were those that were both dangerous and unusual, which the AR-15 is not because it's owned by millions. Now, this isn't just an Illinois problem. States like California, New York, New Jersey, Massachusetts, Maryland, Washington, Rhode Island, Connecticut, and Delaware, I think that's all of them, they all have sweeping bans on ARs and other semi-automatics. And every time these bans are challenged, lower courts twist themselves into knots trying to uphold them like the communist bastards they are. Justice Kavanaugh has already gone on record saying that there's a strong argument that AR-15s are in common use and should be protected. And Justice Thomas said the same thing in dissents when when the court, not him, denied earlier cert petitions. He's always wanted to take the case up. Now, with this case, the court has another chance to settle the issue once and for all. Remember, Kavanaugh did say that the court would take up an assault weapon ban case in the next term or two, and we're in the next term. And the stakes are huge, guys. If the Supreme Court takes the case and rules against Cook County, it could destroy and strike down all assault weapon bans nationwide. If they refuse, or worse, uphold the ban, it could embolden anti-gun politicians everywhere to push even broader restrictions. Now, Second Amendment Foundation's petition lays out several main reasons why the Supreme Court should step in. Number one, lower court confusion. Circuits can't agree on how to apply Bruen and Heller. Some courts say ARs aren't even arms, while others dodge the issue entirely. Number two is the critical national importance. This isn't about fringe weapons, it's about the most popular rifle in America. Number three, it's direct conflict with Supreme Court precedent. The Seventh Circuit's reasoning flat out contradicts Heller, which recognized that all bearable firearms are arms, and Bruen, which rejected the balancing tests. Number four is a clean vehicle for review, meaning there are no factual disputes here. Everyone agrees the AR-15s are semi-automatic rifles owned by millions. The only issue is whether the Constitution protects them. The Supreme Court now has the petition in front of them. They could deny it, as they've done before, hold it while other cases develop, because there are several AWB cases in the higher levels of the judicial system, or they could grant certiorari and finally decide whether bans on ARs are constitutional. And if they grant review, we could see oral arguments in 2026 and a decision by June. So let's cut to the heart of it. If courts can say that the Second Amendment doesn't cover the AR-15, then nothing stops them from moving the line again tomorrow. Today it's AR-15s, tomorrow it could be semi-automatic shotguns, then all semi-automatic pistols, and then we would need a complete reset. This case could decide whether the government can outlaw firearms that are common, popular, and overwhelmingly owned by law-abiding citizens. This is one of the most important Second Amendment case topics in our lifetime. The AR-15 isn't just a rifle, it's America's rifle. If the Supreme Court doesn't step in, the door's wide open for lawmakers to chip away until nothing's left of the right to keep and bear arms. Stay tuned to the channel because I will keep you updated every single step of the way. Make sure you like, share, and subscribe so more people hear about what's really happening with the attack on our Second Amendment. As always, keep fighting for freedom, y'all. Support those who support you. Join groups like SAF, FPC, and others. Links are in the description. Hope you have a great day. Stay free.